Hi, good morning. This is Rajeshkumar. Today we are going to analyze one problem question on criminal law, including the Criminal Damages Act 1971, Theft Act 1968, and the Fraud Act 2006. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through this slide completely. Let's move on to the problem question. Annie has hired Zoltan, a local plumber, to renovate her bathroom. As Zoltan is installing the basin, he gets a phone call. Zoltan uses one hand to answer the phone call and drop the basin, causing the serious cracks. He decides not to tell Annie as he is worried about bad online reviews. Zoltan installs the basin, hoping that Annie would not realize it was damaged. In fact, the basin soon starts leaking. When Annie left for work that morning, she told Zoltan to help himself to tea. As lunchtime approached, Zoltan was hungry. He searched Annie's kitchen cupboard and made himself a sandwich. He then wandered upstairs, and in the bedroom, he found an envelope filled with 20 pounds notes. Zoltan took 40 pounds, thinking Annie would not notice that the money was missing. Later that day, Zoltan goes to a laundromat to wash his work clothes. He has only one coin in his pocket, and when he tries to put the coin in the machine slot, he finds it does not fit. Zoltan then realizes it is a foreign currency. And third, he goes to the Lordman next door. This time, Zoltan is successful in using the foreign coin and his laundry is washed. Here, we are going to give the scenario and we are going to analyze that scenario one by one. Zoltan action regarding the basin could lead to a change of criminal damage under the Section 11 of Criminal Damage Act 1971. The criminal damage involves destroying or damaging a property belonging to another without a lawful excuse. In this case, Zoltan's act of dropping the basin could significant cracks, rendering it less useful, which satisfy the definition of damage as per Morfitz versus Solman in 1990 case. Although there is no evidence of intent, Zoltan's failure to take proper care while handling the basin demonstrates recklessness. Under R versus G in 2003 case, recklessness is established if the defendant is aware of a risk that their action may cause damage and acts unreasonably in circumstances. Zoltan's decision to answer a phone call while holding the basin shows disregard for the obvious risk of dropping it. In other words, Zoltan could be charged with the criminal damage under the Section 11 of the Criminal Damage Act 1971. The offense requires proof that Zoltan intentionally or recklessly caused damage to the property belonging to another. Zoltan dropped the basin while installing it and decided not to inform Annie about the damage, thus failing to prevent further harm when it leaked. While the initial dropping of the basin might not be intentional, the reckless installation of the damaged basin and the subsequent concealment satisfy the mens rea for the criminal damage. The scenario A, if you were a prosecutor, what offenses, if any, would you charge in relation to Zoltan and the basin? Now, the scenario 2 is explaining your reason in relation to the same scenario. The key elements of the criminal damage are present. The basin was damaged. Zoltan acted recklessly, and Annie was not informed of the damage, depriving her of the opportunity to address it. His omission to inform Annie further suggests the culpability, as this action conceals the damage caused. In other words, the actress roles of the criminal damage involves the destruction or the damage of the property, and the basins, crack, and subsequent leakage qualify as such damages. The mens rea, as defined in R versus G and R in 2003 case, requires that the defendant either intend to cause damage or was reckless as to whether damage would occur. In Zoltan's decision to install the damaged basin, despite knowing it was cracked, demonstrates recklessness. The prosecution could argue that Zoltan's failure to inform Annie exacerbated the damage, fulfilling the elements of the offense. Let's move on to the third scenario. If you were the prosecutor, and what offenses, if any, would you charge in relation to the Zoltan and the sandwich? Zoltan's action of making a sandwich may amount to theft under Section 11 of the Theft Act 1968, which requires appropriation of the property belonging to another, dishonestly with the intent to permanently deprive. Appor- Appropriation is defined broadly in R versus Gomez in 1993 case and include assuming any right of the owner even with their consent. A Zoltan's taking the sandwich without the permission could amount to the theft under Section 11 of the Theft Act 1968. The theft requires a proof of appropriation, a property belonging to another, and dishonesty and intent to permanently deprive. Zoltans appropriated the sandwich, which was Annie's property, without her consent, and the act was dishonest under the standards set in Ivy versus Genting Casino's case in 2017. The fourth scenario. In the same case as scenario 3, if you were a prosecutor, what offenses, if any, would you charge in relation to Zoltan and the sandwich? We have to explain the reasoning in relation to the same scenario here, and his general permission to help himself to tea could imply consent for making sandwich. However, Section 2(1)(b) of the Theft Act 1968 permits a defense of belief in consent only if the defendant genuinely believe the owner would consent. If Zoltan exceeds the scope of Annie's permission, his action may still constitute theft under the subjective dishonesty test in IV versus Genting Casinos in 2017 case, where Zoltan's appropriation was dishonest and depends on whether an ordinary person would consider it dishonest to make a sandwich without explicit permission. In other words, Zoltan appropriated the sandwich when he took it from Annie's kitchen. The food qualifies as the property under the Section 4 of the Theft Act, while Annie invited Zoltan to help himself to tea. This does not extend to food unless explicitly stated, making his action unauthorized. Applying the IV test for dishonesty, Zoltan believes that Annie would not consent to his taking the sandwich, establishes his dishonesty. Additionally, Zoltan's intent to eat the sandwich satisfies the requirement of intent to permanently deprive Annie of her property. In the same scenario, what arguments could be raised by the defense in relation to the charges in the same scenario? Zoltan could argue that Annie's permission to help himself to tea extended to food and that he genuinely believed she would not object to him making a sandwich. This belief negates the dishonesty under the section 2(1)(b). In other words, Zoltan might argue that Annie's invitation to help himself to tea extended to making a sandwich and he genuinely believed he had her implicit consent. This defense would rely on the Section 2(1)(b) of the Theft Act 1968, which states that a person is not dishonest if they believe they have the owner's consent. In the same scenario, how would you respond to the arguments raised by the defense in the E category? While Zoltan's belief in consent may seem reasonable, his failure to seek explicit permission could undermine this defense. In R versus Hinks case in 2000, even apparently consensual actions were deemed appropriation, demonstrating that consent must be clear and within the reasonable boundaries. The fact that Zoltan searched Annie's cupboard, which goes beyond simply making tea, and weaken his claim of honest belief. The prosecution would counter by emphasizing that Annie explicitly offered tea and not food, and there is no indication that this invitation extended to take a sandwich. The subjective belief of the concerned must be genuine, but the reasonableness of Zoltan's belief would be scrutinized under the IV standard, which focuses on whether his action fell short of ordinary standards of the honesty. Let's move on to the another scenario. If you were the prosecutor, what offenses, if any, would you charge in the matter of taking the 40 pounds? Zoltan's act of taking the 40 pounds from the envelope constitutes burglary under the section 91B of the Theft Act 1968. Burglary occurs when a person enters a building or part of a building as a trespasser and commits or intends to commit theft, criminal damage, or infliction of grievously bodily harm. The taking of 40 pounds from Annie's bedroom could be charged as a theft under the Section 11 of the Theft Act 1968. Zoltan appropriated the money, which was Annie's property, without her consent, and his intention to permanently deprive her of it is an evidence. In the same scenario, explain your reason in relation to if you are a prosecutor and what offences, if any, would you charge in the matter of taking the 40 pounds. While Zoltan had permission to be in Annie's home to work, he exceeded this permission by entering her bedroom and taking money from the envelope. This makes him a trespasser under R versus Jones and Smith case in 1976, which established that a person who enters the building with the permission but exceed the scope of that permission is a trespasser. And his bedroom qualifies as a part of the building under R versus Wongton in a case in 1979, and taking the money satisfies the theft elements. The Zoltan act of taking the 40 pounds satisfied the actor's risk of the theft. The money was clearly Annie's property, and Zoltan took it without her consent, knowing she would not have authorized the appropriation. His belief that Annie would not notice does not negate dishonesty under IV versus Genting Casino's case in 2017. By spending the money, Zoltan demonstrated his intent to permanently deprive Annie of it. So, what argument could be raised by the defense in relation to the charges above? Zoltan may argue that he did not consider himself a trespasser because he was invited into the house to work, and he believed Annie would not notice or mind the small amount he took. Zoltan might claim that he intended to borrow the money and planned to return it later, negating the mens rea of intent to permanently deprive. Alternatively, he might argue that he thought Annie would not mind him taking a small amount of money, invoking a mistaken belief under the Section 21A of the Theft Act. If you were a prosecutor, what offences, if any, would you charge in matter of the laundry? The Zoltan Act of using the foreign currency to operate the washing machine constitute a fraud by the false representation under the Section 21A of Fraud Act 2006. This offense occurs when a person dishonestly make a false representation intending to make a gain for themselves or cause the loss to another. The resultant use of a foreign coin to operate the laundry machine could be charged as fraud by the false representation. Under Section 2 of the Fraud Act 2006, a fraud requires a proof that the defendant made a false representation intending to gain or the cause the loss, and the act was dishonest. The resultant's act of inserting a foreign coin falsely represented that he was paying the required fee for the laundry service. If you were the prosecutor, what offenses if you charge in match of the laundry and give the reasons for your answer in the same scenario? Zoltan knowingly used a coin that was not the correct currency, representing it as valid payments. This constitute a false representation under Section 22A. His intent to gain a service loan, that is the laundry, satisfied the requirement of the intent under Section 21B. The test for the dishonesty under IV versus Genting Casino's case is met because an ordinary person would consider Zoltan's action as dishonest. The actus reus of the fraud involves making a false representation, which Zoltan did by using a coin, and that was not the valid currency. The mens rea requires a dishonesty and an intent to make a gain, both of which are present as Zoltan knowingly used the foreign coin to obtain the laundry services without paying the appropriate fees. His action would fail the IV test for honesty, as a reasonable person would consider his conduct as dishonest. To conclude, Zoltan could be charged with the criminal damage for the basin, theft for the sandwich, and the 40 pounds on the fraud by the false representation for using the foreign coin at the laundry, while his defenses might include the claims of implied consent or intent to return. These are unlikely to succeed when assessed against the statutory requirements and the case law's precedents. Zoltan can be charged with the criminal damage for the basin under the Criminal Damage Act 1971, theft for the sandwich under the Theft Act 1968, burglary for taking the 40 pounds under Section 91B of the Theft Act 1968, and fraud by the false representation of the laundry incident under the Fraud Act 2006. Thank you.